Chapter 1. The envelope smelled like a law office. Not the sharp antiseptic smell of a modern firm, but the older kind. Dusty. Slightly sweet. The kind of smell that clings to documents that have been handled too many times by too many careful hands. It was addressed to Daniel. I almost didn't open it. I say almost because that word is doing a lot of work in this story. Almost is the distance between the woman I was on the morning of March 19th, standing in my kitchen in wool socks, holding a cup of coffee that was still too hot to drink, and the woman I became 11 minutes later, when I understood exactly what I was holding. It was a property transfer confirmation. Standard format. County recorder seal in the top right corner. Blue ink, slightly smudged the way government stamps always are. Our address. Our parcel number. I knew that number the way I know my own date of birth. I had typed it into more documents than I could count. And there, on line 14 in the transferring party field, my name, my signature, dated March 4th. I had been in Denver on March 4th. I have the Marriott receipt. I have the Delta flight manifest. I have the laptop login timestamp from our firm's VPN server. 9:47 a.m. Denver IP address. Because I was reviewing a commercial escrow file for a client while eating a room service breakfast I never finished. I set the coffee down very carefully. I did not panic. I want to be clear about that. I am telling you this not to sound impressive, but because it matters, because the absence of panic is exactly what made everything that followed possible. I read the document 3 more times. Then I took my phone off the counter, walked to the window where the morning light was better, and photographed every single page. Then I put it back in the envelope, resealed it with a damp sponge from under the sink, and placed it exactly where I had found it. Daniel never knew I had touched it. That was the moment. Not the betrayal itself. The betrayal had been building for years like water damage behind a wall. This was just the morning the ceiling finally showed a stain. And I am, professionally speaking, very good at reading stains. Chapter 2. Let me tell you what I do for a living, because it matters more than anything else in this story. My name is not important. My title is Senior Real Estate Title Auditor, licensed in 4 states, employed for 9 years at Carmichael & Associates Title Insurance, one of the 12 largest title firms in the region. We insure property transactions. We are the last line of defense between a clean sale and a legal catastrophe. My specific job is to find fraud before it becomes someone else's problem. I review chains of title, the legal history of who has owned a property, when and under what conditions. I look for breaks in that chain. Forged signatures, backdated notarizations, fraudulent powers of attorney, liens that were never properly discharged. I have reviewed over 2,200 property files in 9 years. I have flagged 34 cases for fraud investigation. I have testified as an expert witness in 3 federal proceedings, the most recent of which resulted in a 6-year sentence for a mortgage broker in Cuyahoga County, who thought he was smarter than the paper trail he left behind. He was not. Nobody is smarter than their paper trail. This is the first thing I teach the junior auditors who rotate through our department. The paper always talks. You just have to know how to listen. I met Daniel at a continuing education seminar in October 2016. He was there representing his family's small property management company, Hallbrook Family Properties LLC, 3 residential units, incorporated in 2009. He was warm. He was funny. He had the kind of laugh that made a room feel smaller in a good way. We were married in June 2018. His mother, Renata Hallbrook, attended our wedding in a cream dress that was close enough to white to be deliberate. She hugged me at the reception and said, "Your family now, sweetheart," in a tone that sounded like a land acknowledgement. Technically warm, fundamentally territorial. I noticed. I filed it away. I did not act on it. That is also part of my professional training. You do not move on a suspicion. You wait for documentation. Our home, a 4-bedroom colonial on Brentfield Drive, purchased in my name and Daniel's name jointly in September 2019 for $387,000, was the first significant asset either of us had owned independently of his family. I remember Renata's expression at the closing dinner. She smiled the entire time. She asked 3 times about the deed structure, who was listed in what order, whether we'd considered adding a family trust for estate planning purposes. Daniel said, "Mom, we just signed the papers today." She laughed and touched his arm and said, "I just want to protect you, baby." I wrote the word trust in the margin of my mental notepad, underlined it twice. 14 months later, I was standing at my kitchen window photographing a forged transfer document with my name on it. I was not surprised. I was, if I am being precise, simply ready. Chapter 3. There were 3 moments before the envelope. 3 moments I returned to obsessively in the weeks that followed, not with regret, but with the cold satisfaction of a retrospective audit. Each one in isolation was deniable. Together they were a pattern. And patterns in my profession are everything. Incident 1. The deed conversation, November 2019. It was 2 months after we closed on Brentfield Drive. Sunday dinner at Renata and Gerald's house. Pot roast, good wine, the careful performance of a close family. Renata brought it up over dessert. She had a way of weaponizing the relaxed moment, waiting until everyone's guard dropped, until the wine was poured and the food was good, and then she'd reach across the table and twist something. "I've been thinking," she said, in the tone she used for things she had been thinking about for much longer than she was admitting, about the house. About what happens if, God forbid, something happened to one of you. Daniel looked up. "Mom, we have wills. Wills take time. Probate is a nightmare. I've seen it destroy families." She looked at me then. Direct. Assessing. If we were just on the deed, even as a secondary party, we could step in immediately. Protect the asset. Protect Daniel. Protect Daniel from what? I asked. My voice was pleasant. My voice is always pleasant. A half-second pause. A smile that didn't touch her eyes. From the process, sweetheart. It's nothing personal. It's just practical. We'll think about it, Daniel said, which in our marriage was his version of changing the subject. Renata nodded slowly, the way a chess player nods when their opponent makes a move that doesn't change the outcome. Gerald, who had been quietly disassembling his crème brûlée, said without looking up, "Smart women plan ahead." I was not sure if that was directed at me or at his wife. I let it go. I documented it in a Notes app entry timestamped 9:14 p.m., November 17, 2019. R. Asked to be added to deed. Framed as protection. Declined. Incident 2. The withdrawn funds. March 2021. Daniel and I had a joint account for household expenses, utilities, maintenance, the occasional repair. We kept a standing balance of approximately $22,000 as a buffer, the way you do when you own a house and distrust the universe. On March 8, 2021, $18,500 left that account in a single wire transfer. I found it on a Tuesday morning. I called Daniel immediately. Pause that lasted too long. Dad needed it. There was an issue with one of the rental units. A structural thing. He said he'd pay it back within 60 days. From our household account. He was in a tight spot. Daniel. That is our emergency fund. It's a loan. It's fine. He's my dad. Gerald paid back $6,200 over the following 8 months. The remaining $12,300 was never mentioned again. When I raised it at a family dinner in December 2021, Renata looked at me with an expression of polite, weaponized confusion, the kind designed to make you feel small for remembering. "I think you might be misremembering the amount," she said, refilling her wine. "Gerald, wasn't it closer to 5? Gerald nodded without hesitation. "Something like that." Daniel looked at his plate. I looked at Renata. I smiled. I had the wire transfer confirmation saved in a folder on my encrypted drive labeled, simply, Holbrook. Incident 3. The refinance leak. August 2022. In the summer of 2022, Daniel and I began exploring a cash-out refinance on Brentfield Drive. The property had appreciated to approximately $461,000. We were exploring pulling $55,000 in equity for a renovation, the kitchen primarily and a back deck. I made the mistake, my only one in this entire timeline, and I have thought about it often, of mentioning this to Daniel in the presence of his sister Courtney at a birthday lunch in late July. Courtney Holbrook had her real estate license. She had been trying to transition out of property management into sales for 2 years with moderate success. On August 3rd, I received a call from our mortgage broker. A competing offer had come in on a property 2 blocks from ours, a nearly identical colonial, listed at $449,000. The buyers had made a preemptive cash offer. The listing agent? A colleague of Courtney's from the same brokerage. The competing listing had been activated on July 31st, 3 days after the birthday lunch. It depressed our appraised value by $17,000. Our refinance fell through. When I mentioned to Daniel that the timing felt deliberate, he said, and I want you to understand he said this with complete sincerity, because he is genuinely a good person who has been catastrophically conditioned, Courtney wouldn't do that. She doesn't even know your broker's name. She knows ours, I said. He didn't have an answer for that. I added the appraisal report, the competing listing activation date, and Courtney's brokerage affiliation to the Holbrook folder. It now had 23 files in it. I kept smiling at Sunday dinners. I kept refilling Renata's wine. I kept waiting. The paper always talks. You just have to know how to listen. Chapter 4. The dinner was Daniel's idea. 5 years of marriage. He wanted to celebrate. Not a restaurant, not a weekend away, but a proper sit-down at Brentfield Drive. The house we had built together. He spent 2 days cleaning the gutters, pressure washing the back patio, buying good wine. He researched for 3 hours on his phone. I watched him do all of this and felt something that I can only describe as a specific kind of grief, the kind that arrives before the loss, when you can already see the shape of what's coming but the other person is still arranging flowers. The guest list was small. Daniel's parents, Courtney and her husband Marcus, Daniel's college friend Phil and his wife, our neighbors the Okafor Bennetts. I made osso buco. I set the table with the good linen. I opened a 2018 Burrolo that I had been saving for something that deserved it. The evening was, on its surface, lovely. Renata arrived in a silk blouse the color of champagne and spent the first 20 minutes conducting what I recognized as a quiet inventory of the house, touching surfaces, opening the door to the renovated powder room we'd finally finished in January, remarking on the new light fixtures with a proprietary appreciation that made my jaw tighten in a way I did not allow to reach my face. "You've done so much with it," she said, in the tone people use for rental properties they are considering purchasing. "We have," I said. Gerald shook Daniel's hand and said the kitchen smelled incredible. Courtney hugged me and asked if I was still thinking about the deck renovation, in a voice so perfectly calibrated to innocent curiosity that I almost. Dinner was warm and loud and almost normal. Phil told a long story about a camping trip that went wrong in a funny way. The Okafor Bennetts brought a dessert wine that turned out to be extraordinary. Daniel was happy, genuinely, completely happy, and I kept that image of him in my chest like a coal I was careful not to breathe on. Then Gerald tapped his glass. "I want to say something," he announced, standing. He was a large man, broad-shouldered, the kind of physical presence that had probably once commanded rooms effortlessly. 5 years. This house. This family. He gestured vaguely at the walls, the ceiling, at me and Daniel. "It's a lot to be proud of." Daniel said, "Thanks, Dad," and raised his glass. Then Renata stood. She had prepared this. I knew it the way I know a document has been backdated, not from a single detail but from the cumulative wrongness of the texture. "I just want to say," she began, her voice warm and slightly trembling in the practiced way of someone who has rehearsed the trembling, "that this home, this beautiful home, is the heart of this family. It belongs to all of us in the ways that matter." She looked at Daniel. She looked at Courtney. She looked finally at me. "To family," she said. "And to everything we protect together." The table echoed, "To family." Daniel squeezed my hand under the table. I squeezed back. I smiled at Renata across the candlelight. Inside, something went very quiet and very cold, the specific stillness I get when I am looking at a document and the numbers have stopped adding up and I understand with complete professional certainty that what I am holding is evidence. It belongs to all of us. She had already filed it. She already knew. The March 4th document had not been an impulsive act. This toast was a celebration. A private, deniable, devastating celebration, made in my dining room over my osso buco with my good Barolo. I refilled her glass. I did not say a word. 3 weeks later. Chapter 5. I want to walk you through what I found exactly because the details matter. In my experience, details are the only thing that ever truly matters. The property transfer confirmation I photographed on March 19th listed a deed transfer executed on March 4th. A quitclaim deed specifically, which is the instrument of choice for fraudulent property transfers because it requires no title search, no lender approval, and in many counties minimal notarization scrutiny. It transfers whatever interest the grantor has, or claims to have, in a property. Quickly. Quietly. The grantor on this document was listed as myself and Daniel. The grantee was Holbrook Family Properties LLC. Our home. Transferred to his family's company. My signature on line 22 was a competent forgery, not amateur work. The letter spacing was slightly wider than my natural hand. The pressure inconsistency you can only detect under a loop or high-resolution scan. Someone had studied my signature. Probably from the original 2019 closing documents, which Renata had been present for and had handled. I remembered her asking to look at the paperwork before Daniel signed, just to understand it. I had let her. That was the second and last mistake I made in this timeline. I pulled the recorded copy from the county recorder's online portal at 11:23 p.m. on March 19th, using my professional credentials. Recorded March 7th. 3 days after the purported signing. I cross-referenced with 4 documents I retrieved within the next 40 minutes. 1. My Marriott residence in Receipt, Denver, Colorado. Check-in March 3rd. Check-out March 6th. Total, $412.17. 2. Delta Airlines Flight Manifest. Confirmation code DXLR88. Departure Cincinnati/Northern Kentucky Airport 7:14 a.m. March 3rd. Return flight March 6th, 4:52 p.m. 3. Carmichael and Associates VPN access log. My credentials, Denver IP address 17256. 14203, login timestamp March 4th, 9:47 a.m. Session duration, 4 hours 12 minutes. 4. The notarization stamp on the quitclaim deed. A notary public named R. Stills, commission number 2018-44471, operating out of a UPS store on Galbraith Road, 14 miles from Gerald and Renata's house. I looked up R. Stills in the Ohio Notary Public Registry. Renata Holbrook's maiden name is Renata Stills. She had let her notary commission lapse in 2021. The stamp being used on this document was from an expired commission, which meant the notarization itself was legally void, which meant the recorded deed was fraudulent on 2 independent grounds: forged grantor signature and invalid notarization. I sat back in my office chair. It was 12:41 a.m. The house was quiet. Daniel was asleep upstairs. I opened a new folder on my encrypted drive. I labeled it Holbrook Active. Then I found the second document. It had been recorded 6 weeks earlier, January 19th. I had missed it because I had not known to look. It was a power of attorney, granting Gerald Raymond Holbrook the authority to execute property transactions on my behalf and Daniel's behalf, effective January 1st through December 31st of the current year. Both are signatures. Both forged. Notarized by R. Stills. The POA was the architecture. The quitclaim deed was the execution. The POA gave Gerald the legal appearance of authority to sign on our behalf. The deed transferred the property using that apparent authority. It was, professionally speaking, a sophisticated 2-step fraud. It was also, professionally speaking, the single most thoroughly documented fraud I had ever personally encountered, because the people who executed it had no idea that one of the two people they were stealing from spent 9 years learning exactly how to take it apart. I added 11 files to the Holbrook active folder. I made a cup of tea. I did not sleep. By 4 a.m. I had a complete forensic timeline, 14 pages, single-spaced with exhibit labels. By 6 a.m. I knew exactly what I was going to do. Not because I was angry. I want to be precise about this. Anger is a liability. Anger makes you move too fast, talk too much, tip your hand. What I felt was something closer to clarity. The specific, crystalline focus of a professional who has been handed the clearest case of their career and has every tool they need already sharpened. I showered. I made Daniel breakfast. I kissed him goodbye when he left for work at 8:15 a.m. Then I sat down at my desk and began. Chapter 6. 11 days. I want to account for each one. The first principle of any counterfraud operation is containment. You do not alert the subject. The moment a fraudulent actor knows they are under scrutiny, assets move, documents disappear, and narratives consolidate. Renata Holbrook had been managing family narratives for 30 years. If she knew I had found the deed, she would have 3 alternative explanations assembled before I finished the sentence. She would not know. Not until it was no longer useful for her to know. Day 1, March 20th. I contacted the Hamilton County Recorder's Office at 9:02 a.m. Not as a wife. As a senior title auditor with professional standing and 9 years of relationships in county records departments across 4 states. I spoke with a senior deputy recorder I had worked with on 2 previous fraud cases. I explained in precise technical language that I had identified a potentially fraudulent quitclaim deed and an associated invalid power of attorney recorded against parcel number 145-0033-0224-00, our parcel number, and that I was initiating a formal title fraud dispute. She pulled both documents while I was on the phone. The silence on her end when she saw the expired notary commission number lasted approximately 4 seconds. I'm going to flag these for our fraud review unit, she said. I'd appreciate that, I said. I'll have a formal complaint and supporting exhibit package to you by end of business tomorrow. I had it to her by 3:47 p.m. the same day. 14 pages. Every exhibit labeled, every timestamp cross-referenced, the Denver alibi documented across 3 independent sources. A cover memo that cited the specific Ohio Revised Code sections, 2913.02 theft, 2913.31 forgery, and 5301.01 deed execution requirements. That had been violated. I had written more complex memos on slower mornings. Day 2, March 21st. I called Margaret Osei-Bonsu. She is a probate and real estate litigation attorney I had referred clients to on 4 separate occasions over the years. Someone who understood exactly what a fraudulent POA combined with a quitclaim deed meant, in terms of both civil liability and criminal exposure. I walked her through the timeline in 22 minutes. She was quiet for a moment after I finished. How long have you known? She asked. 36 hours. And you haven't said anything to the family? No. Another pause. Good. Don't. I'm filing an emergency motion to void both instruments and a lease pendens on the property by Thursday. That freezes any further transfer attempts. I also want to pursue civil fraud damages, I said. The $12,300 from the 2021 wire transfer. The $17,000 appraisal impact from the refinance disruption in August 2022. I have documentation on both. Margaret's tone shifted. The almost imperceptible brightening of a lawyer who has just been handed a case where the client has already done the work. Send me everything, she said. Days 3 and 4, March 22nd to 23rd. I quietly separated our joint household account, a routine maintenance action that required only my signature, since the account was structured as either / or signatory. I moved $19,400 into a new individual account in my name, at a separate institution. This was not concealment. Every dollar was documented. It was simply prudent asset protection during an active fraud investigation, involving a family member with demonstrated access to our financial accounts. I also changed the passwords on every shared financial portal. Quietly. The way you close a window before a storm, not dramatically, just practically. Day 5, March 24th. I drove to the UPS store on Galbraith Road at 7:45 a.m., before it opened, and photographed the exterior and signage for the exhibit package. Then I drove past Gerald and Renata's house, not stopping, not slowing perceptibly, and noted that Gerald's 2020 Ford F-250 was in the driveway at 8:10 a.m. on a weekday. I noted this because the POA had been notarized on a Tuesday morning in January. Gerald had told Daniel he'd been in Columbus that week for a property inspection. He had not been in Columbus. I added this to the exhibit package under Tab F. Subject Location Discrepancy. Day 6, March 25th. Margaret filed the emergency motion to void. The lease pendens was recorded against our parcel number at 2:31 p.m. Our property was now legally frozen. No transfer, sale, or encumbrance could be executed without court approval. I went to Sunday dinner that evening. Renata made her pot roast. Gerald opened a nice Merlot. Courtney talked about a listing she was excited about in Hyde Park. I ate well. I complimented the pot roast. I accepted a second glass of wine. Renata asked if Daniel and I had thought any more about estate planning options. "We've been doing a lot of paperwork lately, actually," I said pleasantly. "It's that time of year." She smiled. I smiled back. Day 7 through 9, March 26th to 28th. Margaret's office made contact with the Hamilton County Prosecutor's Economic Crimes Unit. The forged notary stamp, using an expired commission belonging to a traceable individual, was a significant escalation. This was no longer purely civil. I also filed a formal complaint with the Ohio Division of Real Estate and Professional Licensing against Courtney Holbrook, documenting the timeline of the August 2022 refinance disruption, the birthday lunch disclosure, the competing listing, activation 3 days later, the $17,000 appraisal impact, and the brokerage affiliation. I did not allege. I documented. I let the timeline speak. It spoke clearly. Day 10, March 29th. I told Daniel, "I want to be careful about how I describe this because Daniel is not a villain in this story. He is a man who loved his family so completely and for so long that he had confused love with permission for them to define reality, permission for them to revise history, permission to take whatever they needed because family meant shared ownership of everything, including things that were not theirs." I sat him down at the kitchen table. I opened my laptop. I walked him through every exhibit, every timestamp, every document, in the same measured tone I use when I train junior auditors. He did not speak for a very long time. "My mom's handwriting," he said finally, touching the screen where her notary stamp appeared. "That's her stamp." "Yes," I said. "She forged your signature." "Yes." He put his face in his hands. Not crying. Something quieter and more permanent than crying. The sound a person makes when a load-bearing wall inside them gives way. "What do we do?" he asked. "It's already done," I said. "I need you to sign one document." It was a corrected deed, prepared by Margaret's office, restoring full, unencumbered title to the property in both our names, with a clean chain of title and a formal notation of the fraud instruments being voided. He signed it without reading it. He trusted me. I had always been worth trusting. Day 11, March 30th. I sent Margaret the final exhibit package. 31 files. 847 pages including supporting documentation, cross-referenced and tabbed. Then I made coffee, sat on the back patio in the early spring cold and waited. I did not have to wait long. Chapter 7. It did not happen all at once. That is the thing about a properly constructed legal case. It does not explode. It cascades. One weight shifting transfers pressure to the next point, which transfers to the next, each consequence arriving with the inevitability of physics. April 3rd. A fraud investigator from the Hamilton County Prosecutor's Office contacted Gerald Holbrook by phone, requesting a voluntary interview regarding 2 instruments recorded against Parcel 145-0033-0224-00 in January and March of the current year. Gerald called Daniel 40 minutes later. Daniel did not answer. Gerald called me. I let it go to voicemail. His message was 47 seconds long. He used the words misunderstanding 4 times. April 4th. Renata called me directly. I answered on the 3rd ring. Her voice had a quality I had not heard before. A thinness like paper held up to light. The performance infrastructure was still there, but something underneath it had buckled. I think we need to talk, she said. As a family. I agree, I said. You should bring your attorney. Silence. We don't need attorneys. This is a family matter. Renata. I kept my voice pleasant. I always keep my voice pleasant. The Hamilton County Prosecutor's Office has our complaint. Margaret Osei-Bonsu has filed civil fraud claims totaling $387,000 in property value, $12,300 in misappropriated funds, and $17,000 in documented appraisal damages. This has not been a family matter since March 7th, when you recorded a forged deed against my home. The silence this time was different, longer. The sound of someone standing at the edge of something and finally understanding the drop. She hung up. April 7th. The Ohio Division of Real Estate and Professional Licensing notified Courtney Holbrook that her license was under formal review pending investigation of a complaint alleging conduct prejudicial to a client's financial interest. Her supervising broker was copied. Courtney called Daniel screaming. He listened for 4 minutes and then, quietly and completely out of character, hung up. He told me about it that evening in the same tone people used to report minor weather. April 9th. This is the detail that mattered most structurally. Raymond Kowalski, Gerald's business partner in a separate LLC, Kowalski Holbrook Properties, formed in 2017, had co-signed the backdated power of attorney as a witness. His signature appeared on line 31 of the January 19th document. When the fraud investigator contacted him, Kowalski immediately retained his own counsel and provided a full statement within 48 hours, identifying Gerald as the architect of both instruments and Renata as the executing notary. He produced text messages. He produced a voicemail. The partnership between Kowalski and Gerald dissolved the same day. 3 residential units under Kowalski Holbrook Properties were immediately tied up in a civil dispute regarding asset separation. Gerald's business, in practical terms, ceased to function. April 14th. Margaret called me at 8:47 a.m. They want to settle, she said. I know, I said. The settlement offer arrived by 2 p.m. Full restoration of clean title. Already done. Repayment of $12,300 in misappropriated funds within 30 days. Payment of $17,000 in documented appraisal damages within 60 days. All legal fees. A formal signed acknowledgement, drafted by their own attorney, which I found almost poetic, that both instruments had been executed fraudulently and without our knowledge or consent. In exchange, we would not pursue the criminal referral. Margaret asked me what I wanted to do. I thought about Daniel's face at the kitchen table, his hands over his eyes, the specific sound a person makes when something structural gives way. I thought about Renata's toast. It belongs to all of us in the ways that matter. Take it, I said. With one addition. Courtney's licensing board complaint proceeds independently. We do not withdraw it. We have no standing to withdraw it. It's a regulatory matter now. Make sure they understand that. Their attorney called back within the hour to confirm. They understood. The settlement was executed on April 19th, 31 days after I opened an envelope that smelled like a law office. Chapter 8. It is a Tuesday morning in early May as I write this. The back patio is finished. Not the full renovation we had planned before the refinance fell through, but a version of it. Daniel built most of it himself over 3 weekends in April, in the specific focus way he has of processing difficult things, with his hands with wooden levels and a measuring tape, converting grief into something you can stand on. I brought him coffee both mornings. I sat in a folding chair and watched him work and did not say very much, because there was not very much left to say. The $12,300 cleared our account on May 1st. The $17,000 arrives next week. I have already moved both amounts into a separate savings account I opened in both our names. A new joint account at a new institution, with new routing numbers and no history attached to it. A clean chain of title. That is what we call it in my profession. When every previous encumbrance has been cleared, when the record is unambiguous, when the property belongs precisely and only to who it says it belongs to. That is what we have now. In the legal sense. And in the other sense too, the harder one, the one that does not get recorded in any county database. Daniel has not spoken to his parents since April 4th. He has not spoken to Courtney since the 7th. I did not ask him for this. I would not have asked him for this. These were his decisions made quietly and without drama, in the way he makes all his important decisions. He filed them away and moved forward the same way I do, which is perhaps why we work. I have been asked by Margaret, by colleagues who heard about the case, by a friend who knew the broad outline, whether I feel guilty, whether I feel I went too far, whether I think about what it cost his family. I think about it the way I think about any completed audit, with the dispassionate satisfaction of a professional who identified a problem, documented it precisely, and resolved it through the correct channels. Gerald and Renata Holbrook made a series of deliberate, documented decisions. I made a series of deliberate, documented responses. The consequences belong to their decisions, not to mine. What I did not expect, and I want to be honest about this because I have tried to be honest about everything, was the specific quality of the silence afterward. The absence of Sunday dinners I had been performing my way through for 6 years. The absence of Renata's assessments, Gerald's casual financial entitlement, Courtney's precisely calibrated intrusions. I had not realized how much energy it costs to smile at people who are stealing from you. I have that energy back now. I use it for other things. For Daniel, who is rebuilding something inside himself that will take longer than 31 days, and cannot be resolved through legal channels. For the back patio, which gets the good evening light in May. For a junior auditor at our firm named Priya who reminds me of myself at 26 and who I am teaching, among other things, to listen to what the paper says. The paper always talks. You just have to know and be patient enough and quiet enough and steady enough to listen. That is all I did. That is everything I did. If you have watched this far, you already know why. You recognize something. Maybe not the property fraud, maybe not the specific legal architecture, but the pattern. The Sunday dinners where something was always slightly off. The smile that didn't reach the eyes. The slow, patient erosion of something that was supposed to be yours. That is you. Here is what I want you to know. Documentation is not aggression. Protecting yourself is not betrayal. Knowing your rights is not the same as using them against someone. It is simply the prerequisite for knowing when someone is using the lack of them against you. You do not have to be a title auditor. You have to be paying attention. You have to be willing to trust what the details are telling you, even when the people around you are telling you something else. If this story helped you, share it with one person who needs to hear it. Not for the revenge. For the reminder that competence is the quietest and most durable form of power. Subscribe if you want more stories told this way, precisely, honestly, without filler. And leave a comment with one word. The one word that describes how you felt when the settlement cleared. Mine was level.